Thank you, Chairman Grassley, Ranking Member Durbin. Congratulations to your families and to you for your nominations. Thank you for your service. Mr. Squires, I'll turn to you first, and I have a series of fairly quick questions about patent policy. I am encouraged that you're willing to serve at this pivotal moment in global IP policy and appreciate your taking the time to meet with me. Earlier this month, Senators Tillis, Durbin, Hirono, and I reintroduced the Prevail Act. It includes common sense reforms to the Patent Trial and Appeal Board and will help make it more the fair and efficient form I believe Congress intended in the American Invents Act. Do you think the PTAB needs to be reformed? If so, in what ways? And do you think Prevail could contribute to those reforms?
Thank you, Senator. Thank you for your question, and thank you also for the opportunity to meet in your office. I do think there is need of reform. I think we have almost 15 years of data since the American Invents Act to see the distribution, if you will, between post-grant review and IPRs, and the data seems to be skewed in favor of one versus the other, so reform may help flatten out that curve.
There's a significant pendency problem, about 800,000 unexamined patent applications. Dealing with that will require streamlining and improving the workforce, the PTO. Reducing this backlog will require resources. One of the provisions of the Prevail Act would permanently end the practice of fee diversion. The PTO is entirely fee-funded by the substantial fees paid by those who seek patents. Would you oppose fee diversion at the PTO?
Thank you, Senator. We have a Commerce Secretary also who is very savvy with patents and has lived the patent life in private sector. Fee diversion, I had testified to years ago, almost 18 years ago, should end. The Patent Office should be able to keep its fees and run its system like a business. I think the fee diversion ending would be a positive thing for the Patent Office.
In eBay, the Supreme Court dramatically cut back on the availability of injunctive relief after finding a patent infringement. My Restore Act with Senator Cotton would return patent law to what was literally centuries of tradition by restoring a rebuttable presumption that a patent owner can get an injunction. What is injunctive relief? What does it mean to small inventors, and why is it significant?
Thank you for the question, Senator. Injunctive relief is basically a cease and desist order for operations, sales, manufacturing, any commercialization of a product. It's important to individual inventors because they're coming to the office with their issued patents to get an exclusive right. Right to exclude is a property right, and property right enforcement usually involves kicking out the trespassers. So that's why the individual inventors look to that provision. It also gives them the right, exclusive right as conferred by the monopoly granted by the government to practice, not the right to do anything themselves, but to exclude others. That's what the patent grant means.
In the Section 101 area, the jurisprudence about what is patentable, I think, in fact, the Federal Circuit thinks that the Supreme Court's jurisprudence has ended up getting into a box canyon that's hard to get out of. What's the impact been of critical decisions like Myriad and Alice on cutting-edge technologies like AI and blockchain?
It's created uncertainty throughout the entire process. When a patent's granted, even if they're overcome in the office, those particular eligibility objections, they're litigated and not respected rights once they're in the marketplace, and they're often, vehicles for litigation outside of the merits of infringement, whether the claims read on an accused product.
And has this hurt our competitiveness globally in terms of where cutting-edge technology patents are being filed and advanced?
Thank you, Senator. I believe it has. And as I mentioned in my response to Senator Tillis, we've seen other nations have success with more expansive subject matter. We shouldn't be so constrained.
Thank you. Thank you for your answers across a range of patent issues. Mr. Edlow, if I might, between 2020 and 2021, over 80,000 employment-based green cards for legal employment here in the United States went to waste because the then USCIS leadership didn't adjudicate them, resolve them on time, and that sparked bipartisan concern. Do you agree that wasting green cards that have been authorized by Congress is unfortunate, and these opportunities for legal employment shouldn't be missed? And as director, will you prioritize reducing unnecessary paperwork and improving processes to improve legal employment here in this country?
Senator, thank you so much for the question. You know, in the last 4 years, I've had the privilege of serving in the private sector, and I've seen the need to modernize forms in a way that I never really understood before. If confirmed, I plan on making major gains to modernize our systems, both for vetting and screening purposes, but also to allow attorneys to better send in forms as opposed to still using paper forms, to be able to scan them and then that information be taken in through a PDF process. So absolutely.
Thank you. Last question, if I might, Mr. Chairman. I've been gravely concerned about recent decisions to abruptly end TPS provisions for folks who came to this country under these legal programs from Haiti, from Venezuela, in particular from Afghanistan, and that are leading to hundreds of thousands of people losing their current legal work authorizations at the same time. Businesses in my state and around the country are facing significant labor shortages, and families that are here legally, working legally, are facing a return to countries that are not demonstrably any more stable than they were when they left. As director, would you work to prioritize getting those who are eligible for other pathways to remain here and to work here legally the opportunity to do that, to limit the damage to their lives and to their communities?
Well, Senator, let me start with commending the work of the administration right now in terms of following the law with how TPS is supposed to be. The Secretary is required to make determinations at certain intervals, and if the conditions that led to the initial TPS decision are no longer met, then they need to be terminated. Regardless of that, when someone's here with TPS or another temporary pathway, those are temporary pathways. And if they have...
I'm familiar with the process, sir, and I'm also familiar with the ongoing circumstances in both Haiti and in Afghanistan, and disagree with the determination that we should force back to Afghanistan anyone who came here legally.
Mr. Chairman, if I may...
Senator Brett.
Yes, why don't you go ahead, Mr. Edload, and respond?